party. If you guys have not given an RSVP, please RSVP. It is the one time a year where we can get everybody together just to mingle and say hi and celebrate. And, you know, this is about you guys and acknowledging all of your hard work for the year. So try to go. It is a Friday, the 6th of December, I believe. I think it's the 6th.
Yes.
And we're doing it over at the Cocoa Palm this year. Now, it's a beautiful, beautiful venue. The only thing that I did not take into account, because we booked it when the season was nice and hot and everything, and so now it's cold. So now it's cold. I was having a dinner outside the other night. It is cold, so wear warm clothing to the dinner. This way you guys aren't freezing. And then another thing, the R4 convention is coming out. The information came out today. So we will be going, and we're going to have a large group that's going this year again. I think we have probably, without even counting, well over 80 agents that are getting awards. So we'll have a really good group. Monday is going to be our dinner. I'm going to do a champions dinner, and we're going to go ahead and give you that information. We thought we were going to do it at Toca Madera, but unfortunately they're not available, or there's no openings that night. So we're kind of looking for a spot for Monday night. And then Tuesday is the actual awards where everybody gets on stage. It's my favorite. I'm the one, like, and this is very special to me because I was unable to go last year because of my injury. And then I did go the year before, but I was in pain. Like, living in chronic pain is no fun. You don't enjoy anything. So I am so happy to go this year and celebrate all of you guys. So please make an effort if you can go. I pushed myself to the front of the stage so that I could take your guys' pictures and see you guys coming off the stage. It's literally my favorite time of the year because I get to acknowledge all of your hard work. So look in your emails for that information so you guys can register and you can attend that as well. And with that said, I'm going to turn it over to Rod. I want to thank him again because even though, you know, I feel like I've been in this business, I don't want to date myself, but, you know, forever, and forever, let's say. And the majority of issues and questions, you know, I feel very versed in them, but he gives a sense of security a lot of the time when there's complicated scenarios, and I can always go to him. And as a company, just to have him, you know, as a backbone feels really good. And so I want to thank you for always being here for us, Rod, and for always helping me with anything. A long time. We've had a lot. I forget how many years we've worked together. Probably like 20 years now. 20 plus. So it's been a long journey, and he's helped me navigate so many different things in business, not just, you know, with the office, but in business in general. So I'm going to hand it over to the star of the show.
I want to say something. I want to thank him regarding his support. I was lose my commission for the new policy regarding some message from me, and without him, I can lose all my commission for the last transaction. Thank you for.
Oh, excellent, excellent. Everybody asks me as a lawyer, why do I go around and speak at so many real estate offices? It's like the only place I can go, and I get applause, and I get this. Generally speaking, lawyers aren't people that you like to see, right? But in this particular environment and venue, you do. So Jennifer won't date herself, but I will. I've been doing this 29 years. And out of that, I mean, I think I've represented a RE/MAX franchise associated with you for like 23 to 24 years. It's been a long time. And we've done a lot together, for sure, for the office together. And so that's good. I got a couple things for you. I didn't want to slip this out early because I wanted you guys to get a good night's sleep. I didn't want you up all night knowing that I was going to blast this to you guys. But my new book was delivered on Friday. And so, this is the one that has all the new forms and all the new NAR stuff. So we were able to get it out. You guys are the first guys to get it. Now, what we did to it, you'll notice it's lost some weight since the last version. And I'll tell you why that is. I cleaned it up, number one. And number two, what we've done to it is we've used now the front and back pages to keep the production costs low. So it's actually pretty much the same number of pages with an extra chapter, and I get to keep it at the same price because we eliminated the double ups. Because if you recall, the earlier version, the left page, when you turn the page, the left was always blank for you to write notes in, and then the right had text on it. Now the left and right both have text, and so we're able to keep it a little more concise for you guys. You can write in the margins, there's plenty of space in there. So there you go. We will sell that. $20 is my production cost. It's been the same price for 12 years. It's going to remain $20. There's no inflation. And I've got about, I think, 30 books here that I can get to you guys today, whoever wishes to have one at the end of the lecture. So there you go. Now, Jennifer asked me to come here and speak today, and this will be my 4th time, I think, this year at this office. And the reason we've done that is we've had some material changes, of course, as we all know, to the way that we do real estate. Now, the last time I was here, I think it was right before all the new forms and the NAR nonsense hit. And I think I told you a story. And I told you a story about when I was first in practice and the TDS became a requirement and the AVID became a requirement. And the story went like this. When the AVID came out and agents knew that now they had to do a visual inspection and fill out a form, I heard that the sky was falling. It was over, agents are finished, nobody's gonna have any more work, we're all gonna be at truck masters waiting in line for lessons. That's what I heard when the AVID came out. When we found out that NAR was requiring us to make changes to forms and do commissions differently, guess what I heard? What was the narrative that I heard in the marketplace? The sky's falling, listing agents and buyer's agents are gone, commissions are gone, we're finished, we better go line up for truck masters. Exactly the same thing that I heard with NAVID. And I made a prediction. I don't predict things very often, but my prediction was a couple of months after the changes took place, business would pretty much be as usual. And my clients tell me, I represent about 8,000 agents at the moment through the office. And the consensus seems to be things are running pretty normal. I mean, we do things a little differently, but pretty much things are normal. They're pretty much the way they were before. Listing agents are surviving, buyer's agents are surviving. Yeah, there's some people playing games with commissions, but they're the same jerks we knew before. I mean, you know who they are. If I said, hey, listen, who are you gonna have trouble with in Claremont? If I give you guys a silent card, you're gonna give me 3 names and it's gonna be the same 3 names. And they're the same people that are playing the games with the commissions now. So generally things are running smooth. So why am I here today? To talk about a couple of things. I'm gonna talk about, just very briefly, the new flipper disclosure rule, because there's some misunderstanding about it. Then I'm also gonna talk about the BRPC form, which is one of my favorite forms in the world now, because it's so important if you wanna get commissions as a selling agent. So we're gonna talk about that, and now that that form's been in play for several months, I've got some interesting comments. I've got like 8 comments about it to make it more enforceable and to make it more usable. I also have new forms for December 15th. I don't know if you've seen them or not. There is a change that I'm gonna talk about on the RPA, and there's gonna be a change we're gonna talk about on the BRBC. Only one change for each document that you need to be concerned about. Then we're gonna link out and talk about some miscellaneous topics such as point of sale, inspections, and repairs. And then we'll open form, and then I'm gonna sneak out the door. That's how it's gonna work. So without further delay, now that I've kind of warmed up the crowd, so to speak, let's talk about the new flipper statute. So we heard that on July 1st of this year, that flippers have a new disclosure. And it was all pitched as the flipper rule. The narrative at the governmental level is this applies to flippers. People that buy properties and they buy them to rehab them and resell them, and that's it. And so the narrative is that that's all it applies to. But it's broader than that, and that's why I'm talking about it today. So what does the new law say? First of all, what does it apply to? 1 to 4, there's 3 criteria. If it's a 1 to 4 transaction, residential, single family residence, duplex, triplex, or fourplex, that's condition 1. Number 2, seller accepts an offer within 18 months of the date the deed's recording on their purchase. So if they accept the offer within 18 months of their purchase, that's the second criteria as a seller. Third, if the cost of repairs or renovations during that 18-month period exceed how much? $500. All right, so this is a question. So you buy a house to move into. You move into it, the air conditioning goes out, you put a new air conditioner on, and then you get a job transfer, and in 15 months, you're selling your house. You're now under the scope of the flipper statute. So it's not just guys buying properties for profit. Remember, anytime you have a seller who's selling a property within 18 months of the date that they acquired it, and they've done any repairs, they probably fit within the scope of the flipper statute, and now you have a supplemental disclosure to worry about. So that's the main point I want to make right up front, is that it applies not only to Snuffleupagus house flipping, but it applies to every one of your sellers that sell within an 18-month period who did any repairs at all. So again, the three criteria, it applies to residential 1 to 4. Seller sells it within 18 months of acquiring it and does more than $500 in repairs during that 18-month period. That's it. Those are the only 3 requirements that now kick your new disclosure rule. So what's the new disclosure rule? Well, first off, it's not that complex. You need to disclose all your room additions, structural modifications, and details of all the repairs you made in excess of the $500 number. That's pretty easy to do. Second thing you need to do is now, and this is supplemental to what we've done in the past, is disclose the names and contact number of all the contractors and unlicensed contractors that worked on the property. And that's a requirement of the flippers, the ones that do it professionally, and now that's the requirement for all of your sellers who sell within 18 months of acquiring their property. And that's the real lynch here that's different than what we did this time last year, is that you need to task your sellers, well, if you did work, who did it, and how do we contact them? Whether it's a licensed contractor or unlicensed, the statute applies to both categories. Now, so then the question is, did CAR create a new form for flipper disclosures? Does anybody know the answer to that? No. They created a new form for every other thing on the planet except this new statute, of course. So where do you put this? Does anybody have an idea of where you would put this new flipper disclosure concerning contractor and unlicensed contractor identification? It's not on the SP, it's not on the TDS, it's on the SPQ. So it's on the SPQ and it's at paragraph 7F. And if you go to 7F when this is all over, just read it. It'll cue you into the questions you need to answer anytime you got a seller who sells a property within 18 months of acquisition. It's hidden in the SPQ, but you'll find it there if you remember 7F. 7F, that's the magic number, magic letter to find out where your flipper disclosures are. Now, let me ask you a question. I'm going to give you sort of a way that this applies that it shouldn't apply, if you understand that. So if you represent a successor trustee who lives in New York, who's selling a residence that their parents lived in, are they required to do a TDS? No. So if they're not required to do the TDS, the RPA says you're also not required to do an SPQ if you're a successor trustee. This is somebody in New York, the kid, the son, the parents died here, and he's selling the property that they lived in, and he never lived in it. They bought it, they live in, I don't know, Sun City, California, and now they're selling it. No SPQ, no TDS. We all agree on that because they're a successor trustee seller. So they get a seller exempt disclosure. That's what you do when you're done, right? What if this seller says, oh, the successor trustee says, well, I know the air conditioning heating system is out, so I'm going to just go ahead and replace it so that the new owner has it. And why don't we just paint the property so it looks good? Let's prep it at least a little bit in anticipation of sale. They're still not required to do a TDS. They're still not technically required to do an SPQ, but under the flipper statute, they need to fill out 7F. So I'm giving you sort of a hypothetical where even though your client is exempt from the TDS SPQ, if they repair the property as a successor trustee in anticipation of sale, now they got to go to at least 7F and complete that basic information about the repairs they made, assuming that the property was purchased and sold within 18 months. So I'm assuming, again, the parents had purchased it and sold, and the sale date is within 18 months. You can see how that hypothetical could come up, and it's a real gotcha, because most people would just walk over it and say, hey, this guy, he's a successor trustee, he lives in New York, he never saw the property, he's selling it for his parents, SPQ exempt, TDS exempt, close the deal. But that's not true. Your first question on a successor trustee now has to be what? How long have your parents had the house? If it's 18 months or less, are you gonna prep it for sale by putting a new AC or paint or, bathroom, whatever you're gonna do? If the answer is yes, and it's been 18 months, you gotta do at least the SPQ, paragraph 7F. Yes, ma'am.
So if the parents own the house for many years, and then they pass, and then the trustee has it, does that apply?
No, because they did, it's gotta be an 18-month old.
18 months.
18 month or less. In that case, the successor trustee has no duty to do an SPQ or a TDS. And there's one exception, unless the successor trustee had lived in the property during any point in time during the last 12 months before the sale. Yes.
And then one more question. So if I do have an investor doing that, we do fill out the form with the
7F.
7F, and we put everything that they did and the contact person. If they did it with an online license,
Yes.
with enough permits, you put it there, right?
You always disclose if it's done without permits, and you always disclose if it's done by an unlicensed contractor.
Okay. And so now the other party is asking to do an addendum, saying that it's builder owned or owner builder? No, builder, what's the difference?
I don't know. You tell me.
I'll tell you.
Okay, next question, and I'll get back to you.
Do they need to specify the amount of the repairs or provide a receipt?
Oh, great question. So generally speaking, if it's a recent repair within 18 months, you're not required to actually produce receipts, but I would provide them just to be safe. But great question. Okay, yes, ma'am.
Buyer bought the house, they live there within like 18 months, but no repair, and they want to sell the house. So that's okay, right?
Yeah. If they don't do repairs, there's nothing to disclose.
Okay.
Yeah, yes.
Okay, say there's an appraisal, now there's some lender required repairs, scrape the paint and.
Yep.
Do you include all those, the cost, fees and expenses?
No, because that's done in the context of the transaction.
All right,
That's a request for repairs. That's an RR problem.
all right,
So that's already done.
thank you.
Okay, here we go. Now we're gonna do the next question. We're gonna talk about the BRBC. BRBC. That form came out. It's gonna change in a month. All right, does everybody know that? The BRBC is gonna change in 1 month. It's gonna change in one significant way only. And how is it gonna change? It's gonna change because there's gonna be one paragraph added to the bottom. And what it's gonna do, it's called 2G2. You're gonna see a new one, 2G2. And all it's gonna do is it's gonna say on your BRBC that your buyer does not have sufficient funds to pay commissions and buy a property. So that sets it up for the change in the RPA, which makes the BRBC commission demand an express contingency to the offer. That was the missing component from the beginning.
Okay.
So that's what we're gonna do. So remember, BRBC is now gonna be able, it's gonna represent buyer has insufficient funds to pay commission and purchase. And then the RPA is gonna have another box you check that's gonna say, this transaction is contingent upon the seller paying the commission request. So that's gonna be the only two changes to the BRBC and the RPA that you need to worry about in 30 days. That's it, nothing more, nothing less. Now let's talk about the BRBC. We've seen it in action, and I've got a couple of comments. They're very, very simple, but I'm gonna walk you through each one. The first one is paragraph 1, right up on top. Remember, when you fill it out, it's gotta be between the broker, and I've seen it different than this, the broker and the buyer. This is the commission-based form. It must be between the broker and the buyer. It's not between the salesperson and the buyer. It's broker and buyer, like an RLA should be. So just kind of clarifying that it's a commission agreement. If it doesn't have the broker up front, it's technically probably not enforceable. So broker and buyer, number 1. Then if you have that, remember paragraph 11 requires the broker's consent and initial within 5 days, or the agreement's likely invalid. So once the BRBC is signed by the buyer, it has to be submitted for broker approval and then given back to you for the file. That has to happen. I don't know logistically how you do it here, but I'm just saying it has to have an acknowledgement under paragraph 11 that the broker approves of the terms of the BRBC to make it enforceable. Now, why am I concerned about it being enforceable? Because as soon as we came out with the BRBC and the SPBB, which also goes away, by the way, there will be no SPBB after the 15th. But as soon as we came out with all these new forms, all of a sudden, every agent became a lawyer. And every single agent now is telling other agents that which agreements are not enforceable and why they're not entitled to commission. And they all of a sudden became lawyers overnight, and they seem to have this remarkable understanding of the BRBC from an Oliver Wendell Holmes perspective. And so I'm just telling you, since these agents became all of a sudden experts in this particular form, we might as well do the best we can to make it enforceable. So these are the keys to do that, so we don't have to argue with agents over the forms. Now, before we go on to the third issue with the form, I just want to tell you guys that one thing that I've seen over and over and over again are agents, listing and selling agents, arguing vociferously about these three forms. The way that the BRBC works with the RPA and then SPBB. They argue to the point they get on the cusp of losing the transaction for their buyers and sellers. I'm just telling you, that's the wrong approach. Your main job is to do what? Get the buyer and seller together in a transaction so they get the house, either he sells the house or he buys the house, whatever the case is, depending on who you represent. Put the deal together. We'll work out the forms, do the best that you can. But if you find yourself arguing over the forms and your client's suffering, and I see it over and over again, that's the wrong approach. Diffuse it right away. Submit it to me. I'll fix it. But don't argue with other agents over the enforceability. Again, every one of the agents that I see now is an expert on the forms. They think they're lawyers. But I don't know why this particular form caused that to take place, but it did. That's a reality. Don't let yourself get caught into that argument. Yes, ma'am.
Well, okay, I have a question. One of my old clients said that he ended up putting a deal together, and he wanted to pay his agent. So he wanted to pay his agent 1%. It was written in the contract. The broker, nothing to do with us, the broker wanted more commission because he only wanted to pay 1% to the buyer's agent. Their brokerage wanted more, so they asked for more. So he got mad, and now he's seeking an attorney because he didn't want them to ask for more money because he was paying them 1% and he didn't want the brokerage. So does the brokerage have any right to go ask for more commission?
No, it's only between the buyer and the broker. If the broker rejects the amount that the buyer is willing to either pay or accept, then it's not a deal. I mean, whatever the BRBC is, that's why it's required to have a broker approve. Because if the broker doesn't agree with it, the agreement's invalid, and then your buyer can go to one of the 5,000 agents around the corner and get them to do it on the terms that they want. So in other words, the broker has the ability to decline the BRBC under paragraph 11. If they don't sign it in 5 days, they can disagree with what the buyer has proposed. But they can't just override it and say, I want 2%, so now we're going to, on our own, modify the form without the buyer's consent and against the buyer's desires. The broker cannot do that.
Wouldn't the broker's actions be a violation of agency law?
Not necessarily, because the broker and agent together represent the buyer. And so if there's no agreement on commission, that's the whole point of the form. So if the buyer says, I only want to do 1%, if that's all they want to pay, that's really it. And the buyer and the broker says, I won't do a deal on 1%, then the broker can invalidate the agreement, even though the agent has already put the deal together with the buyer. It's not the buyer's and agent's deal, it's the buyer broker agreement, which I'm glad you asked that question because it highlighted why the agreement has to be with the broker in the first place, which was my very first comment about the BRBC. Okay, that's exactly why. Because under paragraph 11, the broker can invalidate it in 5 days, and then the buyer can go somewhere else and negotiate a different deal if your broker didn't want to do that deal. All right, so now let's talk about a beginning and ending date. So this agreement has the BRBC, an automatic expiration, right? What does it say? How long is it good for? 90 days, right? It's good for a 90-day window. So a lot of the agents believe that they can just put a beginning date and just let it expire in 90 days, and that's going to be a valid agreement. The consensus in the legal profession is that without an expiration date being plugged in, the agreement's probably not enforceable, even though it has an auto expiration. Again, it's a disconnect between what the courts will do here and what CAR lawyers think a court will do. Reality is, you need a beginning date and you need an ending date. And it cannot exceed 90 days in order to form a valid agreement. So make sure you have broker, comment number one, you need to have the agreement between the broker and the buyer. Number two, you have a beginning and ending date. All that 90-day window does is provide an automatic expiration if your ending date exceeds 90 days. But you need to put a firm date in there or your agreement's likely unenforceable. And one of the agents that's a listing agent on the other side of your offer that's become a lawyer overnight is probably going to make a deal point about it. So just put a beginning and ending date and it's over with. There's no issue there any longer. Now let's talk about 2B1 and 2B2. What do you know about that? Anybody want to take a gander what those provisions are? Property description. So this is where you can define what kind of property you're going to find for your client. Now, what does that mean? There's two schools of thought. Some agents say, well, I want to keep that agreement really vague because regardless what kind of property I show them, I want this BRBC to include that property. So what I'm going to do is I'm going to say, this applies to all residential properties in the state of California that have more than one bedroom. That's about as broad as you can get. That's almost 100% of the properties available. That's a broad interpretation of 2B1 and 2. Or of the other second school of thought is that you can define it very narrowly and say my client's looking for a house in Upland that consists of 5 bedrooms or greater, that has at least 3 bathrooms, a swimming pool, and a doghouse. And that's about as specific as you can get, or even maybe plug in some addresses that you're showing. So the argument is, the question is, does that affect the enforceability of the agreement, how we describe the property? There's no guidelines from CAR as to which option you select. My recommendation is be as specific as you can without being too specific. So what does that mean? That means, whatever cities you're talking about, if it's, just Upland, Claremont, Rancho, residential 3 bedrooms or greater, try to define it in a way that covers almost all of your client's intentions. That way it's broad enough to cover an offer down the road, yet it's narrow enough to be able to be enforceable if we happen to take it to the board or take it to court. Okay, so I prefer a narrower interpretation, not a broader interpretation of the property description in the BRBC. Now, if you follow my original advice, you're probably not going to do a real BRBC until you make an offer. And that was my original advice to you guys. I still stand by that. So if you use my one-page BRBC, which is a BCA broker compensation agreement, it calls for no commission to show a property. And then my theory was when you write the offer, then you do the BRBC, and then you can just put the address in. And that's fine too. I still think that's the better way to do it. CAR hasn't endorsed that yet, but it complies with Rule 9.1 CRMLS, so it won't get you fined if you do it that way. As long as you have some type of BCA broker compensation agreement, even if it's zero compensation to show a property, you gotta have it in the file. All right? Yes.
Now, if you do the BRBC for, let's say, a month and a half or so, and right, you do it right as you get go open an escrow, but escrow extends a little bit longer past that. You have to drop it.
No, it's once it's in escrow, that one goes infinitely until that deal closes. You don't have to read it. Okay? Anything else? Yes.
So what I don't know if it's right what I do, but what I do, when I meet with my clients, I sign the BRBC first. And then when I submit the offer, I write another with the address.
Perfect.
So
There's no problem with
I already
that.
have one to cover the rule, and I have another for.
I have no problem with that protocol. Anybody else? Yes.
When I submit the offer, the ex-PDP and the seller agree to pay, and when we open the escrow, do we need to submit like a BRDC?
All you need to do is submit one page of the BRBC upon request of the listing agent. So when you open escrow, all you need to do with an offer is submit the RPA. You never submit in the SPDB unless, and never submit a BRBC unless the listing agent requests it. It's on request only. So if the listing agent requests the BRBC, then you only give them the page that has the commission that you're entitled to. That's only one page that are required by terms of the form to give to the listing agent. Not all 5 pages.
So,
Only the page that has the commission on it.
so you mean that when we write, RPA, we have to write, SPBB and, BRBC both.
You got to do all 3 documents together for your file.
Oh,
But then when you submit the offer, only the RPA gets submitted. And then if the listing agent says, I want the BRBC, you submit one page which shows the commission that you negotiated with your client.
oh, that's.
Okay,
I
yes,
only use your form for my buyers, that's it.
perfect.
Can I tell my buyers, if they're not paying commission, we're not gonna go look at that property?
Yeah. You can tell them they're on your own. There's actually a CAR form that allows you to do that, to decline representation, because they anticipated this would be the case. All right, so let's talk about one of, yes,
Sorry,
ma'am.
1 second. So when I submit an offer, I do not have this because the listing agent actually said I had to. And I obviously didn't read the form enough because I thought you had said you write the address and you send it over with,
No, you write all 3 forms for your file. The
right?
BRBC, the RPA, and then the SPBB. That's what you do until the 15th of the month. Then the SPB goes away.
Right.
And then you submit the RPA only.
Oh,
On request, the BRBC listing agent can request it.
okay, so they do request it, so then I send.
If they request it, then you
They have
send
a list.
one page that shows the actual commission that you
Not the whole
negotiated.
thing, so
Not
just
the
the
whole
one commission. page.
That's all the agreement requires. All right, that's it. Now, one other nuance of the BRBC form is what? Exclusive versus non-exclusive. It's right up front on the form. It says that if you want it to be exclusive under 2A2, it can be exclusive or non-exclusive. What's the default on the form? Does it default to an exclusive representation or default to a non-exclusive representation? The BRBC. Non-exclusive. So if you check no boxes, this is a non-exclusive BRBC. What's that mean? What's the difference between exclusive and non-exclusive in terms of the BRBC? It means this. If you're non-exclusive, which is the default on the form, that means you only earn commission if there's what quote unquote broker involvement. We'll talk about that in a few minutes. If you have an exclusive BRBC, that means your clients hired you for whatever period of terms, beginning and end are, and regardless of whether there's broker involvement or not, you get a commission. So if it's exclusive, meaning you check the box in 2A2 that says this is exclusive, and then you also have the buyer acknowledge on paragraph 15 of BRBC that this is exclusive, then that means the buyer's tied to you for their buy for the entire duration of the agreement, subject to canceling 30 days notice. That's all that means. But 99% are non-exclusive. So I just told you the nuance of exclusive BRBCs, but most of them are non-exclusive. So let's talk about what that means. Broker involvement. So I told you that if it's non-exclusive, then the only way you get paid is if there's broker involvement. Now I'm going to go through some examples of broker involvement, and then I'm going to tell you what you need to do about it to get paid, and then I'm going to tell you where to find it in the BRBC. So here we go. So broker involvement means you either provided information about a specific property to the client, or you showed a specific property to the client, whether virtual or in person. Both of them qualify as broker involvement. It means you introduce the buyer to the property, you talk, you email, you say, hey, go look at this one. Even if it's open house, you told them to look at it. That's broker involvement. You wrote an offer, obviously, that's broker involvement. Or you send them a CMA or some other valuation mechanism. Those are all examples of broker involvement. And you need to do that to earn a commission under the BRBC. Now, 99% of the time, this is not an issue because you got a BRBC, an offer, and an SPBB. So obviously you wrote the offer, that's the biggest one here. You wrote the offer, you got broker involvement. So it's obvious. It's the other 10% where you're in a little bit of a contest, maybe with another agent who wrote the offer. Then the question is, well, if you provided, property profile and you showed the property to them in person or virtually, and maybe you, talk to them about valuation, and then they go to somebody else and write the offer up. If you prove broker involvement, technically the broker is entitled to commission. You've earned it under non-exclusive. So why did I bring this to your attention? that would tell me as a selling agent that if I want to prove broker involvement, I have to document what I've done. So now with your buyers as a selling agent, you need to, in writing, document everything you do in case we have a commission claim down the line. So if you provide information, confirm it to them. This confirms, we talked about the property on 123 Legacy Street, and that it's 3 bedrooms, 2 baths, it looks good for you. Let's go see it tomorrow. Let's go see it today. Or if you already showed it, this confirms I showed you the property. Has a lot of great features. Let me know if you want to make an offer. Use email, use text, confirm everything that shows broker involvement, and that goes in your transaction. That way, if there's a dispute over commission later on, I can prove broker involvement through email, text messages, and other forms of communication that are admissible. So you need to be able to prove that. So just to recap, just because it is a little complicated, the BRBC can be exclusive or non-exclusive. 99% of the time, it's non-exclusive, which means you need to prove broker involvement in order to get paid a commission. Broker involvement usually is when you make the offer. But just anticipate from the time you meet the client that you may have to prove it later on. So just start documenting everything you do with each buyer and basically follow up an email. Any questions about that before we go on to another concern about the BRBC form? Okay, the BRBC form has 3 other satellite documents that are referenced in it that nobody knows about. Anybody know that? There's actually 3 documents. They don't auto-load. They're kind of off. You have to know the documents. You have to read it in order to know they're in there, but there's 3. One is called a BIPP. Anybody know that document? BIPP. It's called Buyers, Preferences, and Priorities. And it's basically, I think it's a 1-pager. It allows your buyer to complete this form to tell you what they want and don't want. So if they say, we want a house that's newer than 20 years, it's got to not have a pool, but it's got to have a 15-car garage. Okay, well, if that's what they want, they can put it in the BIPP form. It's referenced only in the BRBC. Nobody reads the BRBC, which is why I created mine, but it is a form that's available in there. It's not required to make the form enforceable, but it is a tool you can use to document what your client's actually looking for. The second form, these are all new forms, didn't exist prior to 4 months ago, is the BFPI form. I'm not making this up. These are actually in the BRBC. BFPI. That form is the buyer's financial requirements, down payments, and payments. So that form was designed for your buyer to fill out to tell you how much money they have, what they can afford as down payment, and what they can afford as payments, so that you could document, theoretically, the financial aspect of your buyer's demands. So that's the second form we have. The third one is BMI-SP. It's called Buyer's Materials Issues. BMI-SP. Now that's a curious form because it's designated in the BRBC as required. It's a required form and nobody in the room knows about it. I guarantee you. No, has anybody ever heard that form? BMI, 1 person out of 42 people has heard of it.
What's the full name again?
BMI-SP. It's called the Buyer's Materials Issues form. And again, it's technically required under the BRBC, but there's no consequence in the BRBC if you don't have it. So it's required, but no harm, no foul. I'm just telling you what the form says. So it's technically a required form. Technically, you probably ought to have it there, but there's no price to pay if you don't. It does not invalidate the BRBC. It just says there it's a required form. And that allows your buyer to basically tell you what's material important. I need a property in Cucamonga, horse property, at least 1 acre. Kind of like the buyer preferences and priorities, but with a slightly different twist to material issues. All right, so there's your 3 forms. That's all I have to say about the BRBC. These are based upon issues that have come up during the scope of the life of this form, which has been about 4 months. These are the comments I have. To make it better, follow the comments and you'll have a more enforceable form. Now, again, just to recap, why did I want to spend so much time with this form? Primarily because, again, a lot of the selling agents, a lot of the listing agents have become lawyers. And they want to invalidate your BRBC by pointing out these, what they believe to be legal defects. So just to take it out of the equation, I want you to be better prepared to complete the form so that the listing agent / new lawyers don't tear it apart and think they don't owe you anything. Okay, that's why I brought it to your attention. Yes, ma'am.
So with the last 3 forms, we started working with the buyer and I have them. But then we just retain them on the file, do we have to?
It's like any other, it's like the offer.
So we present it to the listing agent only upon request?
Those don't have to get presented at all. Yeah, the buyer's preferences are your forms. They're for a selling agent only. They tell the selling agent, it's basically those 3 forms, if you were to print them out and get your buyer to fill them out, all they're saying is that the buyer says, these are important to me, and here's the criteria for me to buy a house. You know, and if you put all 3 forms together, it's gonna tell you their preferences. I'd rather have a 3-bedroom house with 3 bathrooms. It'll tell you material issues. I want it zoned for horses. It'll tell you its finances. I can't pay more than $150,000, and I can only pay $300 a month. Whatever the case might be. Those 3 forms together will work to tell you the kind of property your client's looking for. So it's your option to use them. They're not required except the BMI-SP, but even if you don't do them, there's no consequence. Ma'am.
So if we use the form that you created for us, then we don't have to worry about all these.
You don't have to worry about this except when you write the offer. You still need to use this form when you write the offer, and it still needs to be as complete as possible. So all the comments, like when you write it with an offer, they still need to be with the broker. It still needs to have, you still need to describe the property, in this case, an address, because at that point, you're writing an offer. You know the address that the RBC applies to, and all the other comments still apply. Okay? But if you use my form, it just makes it easier for you to show the property and still demonstrate that you have a written commission agreement. Although it says nothing, you don't owe you nothing to show a house, it basically just satisfies Rule 9.1. Because as soon as the NAR settlement came into play, what did CRMLS do?
The commission.
Yeah, they changed Rule 9.1 to say if a selling agent we discover has shown property without some type of broker compensation agreement signed first, we can fine them $2,500. Now, how are they gonna find out? Well, they will, so just trust me. Use the BRBC. Somebody's gonna find out, somebody's gonna audit a file, and if you don't have it, they can line it up, you're gonna have a $2,500 fine. So that's what CRMLS is doing. At some point, I'm not sure we see CRMLS around here, but at this point, they're still here. At this point, we still have NAR. At this point, we still have CAR. So these are the rules. They're not California law. These are just rules like country club rules, things you have to follow if you're a CRMLS member. Yes.
Are you aware of any agents actually getting that fine?
I've had one client so far in LA that received a $2,500 violation because the buyer went to another agent and told them they didn't have any contract with this agent at all for commission, and then showed him a house that was the same one my client showed him to, and it became a big issue. My client showed him the house, and it was proven they had no prior broker agreement. And then, of course, what did that second selling agent do? Reported him. And then what happened? CRMLS issued a violation and a fine for $2,500. That's how it happened.
Wow.
Okay, so there you go.
Good to know.
So there you go. That's how it gets done. All right. So that's how it gets done. It's always your competition. It's always your competition that's anxious to turn you in and get you fined. And 9.1 is, it's hard to do, but I've seen it done already. So just do yourself a favor. At the very least, before you show property, just get them to sign my one-pager and put it in the file. That way, at least you have a buyer-broker agreement, and it's easier to get a buyer to sign my form that says they owe you nothing than to get them to sign this 5-page, single-page form with all the nonsense in it. I mean, nobody's gonna sign it. I wouldn't sign it. So I'm sure they wouldn't sign it. But I'd sign my form. It's like, oh, you're gonna show me property, I don't owe you anything. Right, we'll negotiate it when I write an offer. Fine, let's go. Yeah, that's the way it goes down. All right, so this is a topic, we're gonna move on. This is a topic we haven't discussed in a while, but it has relevance for the new RPA. So we're gonna talk about the old RPA, which is paragraph 7. There was an issue, 7, I think it was 7B2 and 3. Does anybody remember 7B2 and 3 of the old RPA? It was government inspections, pre-sale inspections, and government retrofit and repairs. Now, it's hidden more in the new RPA, the new version. We haven't talked about it yet but it's exactly the same as it was, and I've seen a couple of sellers stung by it recently, so I thought, let's bring it up again. So you're a listing agent, and you're reviewing an offer, and before you look at the price, before you look at anything, I would go to 3Q5 and 3Q6 and circle 3Q6. The reason I would circle 3Q6 is because 3Q6 says that if your seller signs an offer that has 3Q6 with the seller paying the cost, that means your seller's telling the world that if a government entity comes in and inspects the property pursuant to some sort of a pre-sale inspection requirement, I agree to pay whatever it costs to comply with the government's requirements. That's what you're saying when your seller is allowed to sign a contract with 3Q6 with seller paying the cost. Now, let me give you an example that's going to be terrible. And that way you'll never forget why we don't do this. Azusa has a pre-sale requirement. Yeah, and this is what happened to my client. So my client is a seller, and this happened 12 years ago. And the seller was represented by an agent, not with this office, but an agent from another office, enlisting a tract house in Azusa. They found a buyer, and the offer was signed with the seller being responsible for the cost of the pre-sale inspection report under what now is 3Q5, which is not a big problem. They're going to pay for the report. But also an unlimited agreement under 3Q6, what is today 3Q6, to pay for the cost of government required repairs and retrofit. The pre-sale inspection happened. The city of Azusa said they couldn't find permits for this particular tract house. So they issued a demolition order for the house. They wanted the house demolished and rebuilt. And then who came in next? This particular house was close to the foothills, and the fire department said, well, if you're going to demolish and remodel, you have to comply with the new fire sprinkler requirement too. So the price for the house, the sale price was $405,000 at the time for the house in Azusa. The cost of the government repairs was $425,000. So my client, in order to comply with 3Q6, would have had to sell the house for $405,000 and pay $425,000 to replace it with fire sprinklers. So that's the example, and it happened. This is not make-believe. This actually happened. This was a case that was pending, that was filed, that was litigated. So how do you avoid it? Number one, there's a two-step approach. Number one, if you're a listing agent and you identify that 3Q6 is asking your seller to pay for government retrofit and repairs, strike it out. Omit it by counteroffer. If you have a great offer, but you can't omit it because the selling agent says this is very important to the buyer that your client continue to pay for retrofit repairs, and you haven't had any other offers, then what's your second best guess?
Put a cap on it.
Put a cap on it. And just say, yeah, okay, we'll pay for 3Q6 up to not to exceed $5,000.
Yeah.
That way, the worst case scenario, like in my client's case, instead of rebuilding the house at a loss of $15,000, my client could have just wrote a check for $5,000 or credited and said, you're now obligated to buy it. Okay? Yes, ma'am.
Can you just put a clause saying contingent upon the seller's approval of the cost?
That's what I thought.
You can put that also, but I'd rather just cap it. I'd rather just cap it. Because otherwise, there's a concept in law called illusory contract, and then it becomes to be maybe illusory. Like there wasn't an agreement really in the first place. So I just talk to your client and they say, let's just cap it at $2,500 and see what happens. If they sell it, then your client knows. Even if they come out and they say you got to tear the whole house down, your exposure is $2,500 on the deal. Yes, sir.
When you run the profile and that property shows up, all that information that's from the title companies, wouldn't that have meant there was a permit to get it recorded at the county?
There's a lot of evidence that was permitted.
Yes,
but
sir.
Only the city has the records. So, for example, all the stuff you get from title is third-party information. And what you get from the assessor's office is third-party information. How many of us have ever seen a property or been involved with one where the information at the assessor's office doesn't agree with maybe the title report or maybe doesn't agree with the property you actually see? It happens all the time.
Yeah.
And I was in construction before a lawyer. I worked for my family. And one of the jobs I had between the age of 16 and 18 is I got the privilege of pulling permits. And oftentimes, I mean, at the time when I pulled permits in the 80s, literally all you had to do to get the whole file for a building or a property was give them a copy of your ID, and they gave you the original file. And so what would you do? Guys would just tear things out, take them home. This would be before microfiche. You'd literally have the entire original file. And their hope was that if you wanted a copy, you'd then flag it and give it back, and they'd run the copy and you pay 10 cents. That's what happened. But what I saw a lot of guys do is they would tear things out and just take it home, and the file then was missing. And that's probably what happened on the Azusa property. At some point in time, this tract house was looked at, and somebody pulled the file and looked at it and then probably extracted or lost the actual permit. And that's all it took to get this potato in at the city to give a demolition order for it.
Oh, my goodness.
So just be mindful. 3Q5 and 3Q6 are huge issues for a listing agent. As a listing agent, I would never, ever let my client sign 3Q6 to seller without a cap at the very least. Yes, ma'am.
What was the final result today?
Final result was a compromise. My client spent $100,000 in legal fees over a 3-year period litigating. And then ultimately, we sold the house. The city agreed that we could do some retrofit on it. They admitted that the permits were probably lost. This was a tract house in the middle of other tract houses.
Yeah.
So they finally consented to it. But again, my client spent $100,000 in attorney's fees over a multi-year period. Yeah, just don't let your client get into that rat race. Just get rid of 3Q6. That would, if this listing agent would have got rid of 3Q6, the case would have never existed, and I wouldn't have had enough money to buy a new car.
So real quick, I had an offer on a property in Azusa, sorry, and Q5 is checked,
Yes,
but nothing on Q6.
that's fine. That means your client is agreeing to pay for the inspection, but not the repair. Okay. Now let me ask you $1 million question. Now I'll get these. Can your seller waive pre-sale? Can the buyer and seller waive a pre-sale inspection?
Yes.
Yes.
We got some yeses? No? We got no, yes, no? Okay. A buyer and seller can do anything. So if they want to waive a pre-sale, technically, there's only 3 reports you cannot waive under California law. So if you're sticking just strictly to California law, you can't waive a TDS or NHD, lead disclosure, or fire hardening disclosure. Those are the 3 you cannot waive under the law. You cannot do it. No buyer, no seller, and a 1-to-4 can waive that. Technically, that's not, the pre-sale inspection reports are not, under California law, non-waivable. So technically, theoretically, you can waive them. Now, is it advisable for buyers and sellers to waive a 9A report in LA or to waive a pre-sale inspection in San Pedro? It is not. So if you find yourself, whether you represent a buyer or a seller, and you're going to close a deal where the buyer and seller are waiving a pre-sale inspection report, you have only one obligation in that transaction, and that is to call me, because I need to draft a disclosure to protect you, your client, and the broker from that transaction.
But I got a
your
question.
clients are closing it without the required pre-sale inspection report. I can do it, but you gotta just think in your checklist, if your buyers and sellers are saying, we're gonna close a pre-sale, we're gonna close without pre-sale, we're gonna close without a 9A, we're gonna close without a Department of Water certification, you do nothing other than call me. I need to be involved, broker needs to be involved, because we need to get a waiver that protects your client, yourself, and the broker. That's the only duty you have in the scenario where those are being waived, those reports. Yes, sir.
Is that mandatory by the city though?
Yeah, they're mandatory by the city, but at the same time, the buyer and seller are, if they want to waive it, they'll accept the deed and you can transfer title and you can close a transaction. Does the city like it? They do not. And what it means generally is that the buyer now is going to be solely responsible for all those costs. And that's my job. So if your buyer and seller say, we're closing it and we don't care, then you have to call me. I have to get a disclosure hold harmless. And it's a pretty nasty disclosure. I mean, it's going to basically tell the buyer, you're acting against broker advice by closing this transaction without a pre-sale report. You're solely responsible for all costs of that pre-sale report, which may include demolition of your entire house, for which you'll have no remedy. I mean, it's that aggressive. But we need to have a waiver like that and a disclosure like that. If you're gonna close any 1 to 4 dwelling without compliance with the city inspection pre-sale. So just keep in mind, again, just to make, I can't even stress how important this is. When you have a pre-sale inspection requirement and you represent a party to the transaction and they're waiving it and closing it without that inspection, you need to call me. That's all there is to it. And I will draft an agreement to present to the buyers and sellers. Okay, yes,
What
the
about
back.
septic?
Go.
What about septic certification, Lolo?
I'm sorry?
Septic?
Septic certifications are negotiated independently.
Okay.
So if you have a septic tank and the buyers and sellers want to waive, they want to waive the report or waive the inspection, that's a separate waiver, but it's not to the level of a pre-sale inspection report. But I'd certainly like to be involved with that. However, the bigger problem is, most of the complaints I have with septic is that they don't know it's a septic tank. And so the buyer closes, they don't know about it, and then it backs up, and now they allege a non-disclosure by the seller. So, oftentimes the public information isn't really obvious of whether the septic or not. There's nothing wrong with a septic tank, as long as it's kept up, or a seepage pit, as long as it's kept up. And then I have this discussion with the buyers. The buyers say this: I just found out I have a septic tank. I want to be paid by the seller. They lie to me. And then I ask them, is there anything wrong with the septic tank? Well, no, it runs well. Well, have you paid any money in order to repair it since the close? Well, no, there's nothing wrong. I haven't paid anything. Well, then in terms of appraisals and value, the septic tank, if it's working, is just as valuable as a sewage line if it's working. So unless you have sustained a loss, your buyers don't get paid just because somebody made a mistake and said it's on sewer when in fact it's on septic. That's one scenario. And that's a discussion I have. And I tell your buyers they don't have a right against anybody, typically. However, the other side of the coin is if the buyer moves in, it immediately backs up, and now they need $50,000 worth of work on the septic. Now we have to go back and say, well, who was negligent? Because now your client has a loss. So if your client has no loss, the fact it's on septic, no harm, no foul. If your client has a loss, now we have the third prong of a claim for negligence, and that is proof of damages. So a claim without damages doesn't go to court. A claim with damages goes to court. Yes, ma'am.
Going back to the retrofitting, so I want to clarify, so you're saying the pre-inspection, if it's only required by a city, because I have deals where some buyers don't do inspections. So I don't need to come to you for a
No.
because we have that. Secondly, how do you know, so if I've always put for 7A, 7B, upon seller's discretion, whether they're gonna pay for anything. But so then I just rely on the home inspection. So if the buyer does a home inspection and they say the toilets aren't up to date and all that stuff, then it's the seller's discretion whether they're gonna change it. Other than the home inspection, how do you know if something's government required?
Well, this is their point. Certain cities have point of sale inspection
Right, so
requirements.
certain cities.
So this applies, so 3Q5 applies to point of sale city inspections. It's very specific to language.
Okay.
So it's ones that are required by the city, technically as a condition to close. Like the 9A report's a classic example in the city of LA. So the 9A report says the seller has to give the report to the buyer prior to close and as a condition to
Right.
close. If the buyer and seller agree to waive the 9A report, what do? You come to me,
Got it.
and I then draft a disclosure that says the
Right,
act
right.
against broker's advice. And then I have all the nasty stuff in there,
Okay,
the
I was
buyer and seller
confused.
signs it.
Okay.
But the home inspection is totally different.
Right.
But the repairs are exactly the same. Like, for example, on the 3Q5, I don't mind if 3Q5 is checked, because that only requires the seller to do what? To pay for the report and provide it, which they're required to do anyways. I do have a problem with 3Q6 under every single circumstance. So my focus today is for you to remember, and all weekend long, 3Q6, all weekend, 3Q6, 3Q6, 3Q6. As a selling agent, as a listing agent, do not let your client sign a 3Q6 contract. Simple as that. Any other comments?
I had a comment.
Yes.
Norco, City of Norco.
Yes.
If you have a septic and you sell that place, they want you to connect to the sewer if there's sewer in that street. It's $10,000.
Yeah.
Just so you know.
Well, I mean, that could happen. I have one property right now that I own, and I thought it'd be cute to connect it to the sewer. It's got a seepage pit. And they have homes they built recently around as well. So I thought, well, now that they built homes, it should be really easy to do. So I had a company come out, and they said, well, you have to go into the street, you have to cut an apron, And by the time we were done with permits, it was $250,000.
Oh my God.
So just keep in mind, if you know that a city like Norco is gonna require you to hook up to public sewer, it may be cheap, like 10 grand, but if you have to start going into a major street, like for example, if they say you have to cut off and close off Hamner, and then, have a flag man on both sides and close it off for 3 days while you connect to a public sewer 100 yards down from your property, that's gonna be a 6-figure project. So that's a big deal. That's a big deal. Yes, sir.
If you cover like that repairs and you put will consider lender repairs and the lender repair comes up, are they on the hook to do it or do they consider yes or no?
I would not put anything in your contract that says seller will consider anything, whether it's 9A, whether it's lender required repairs. I would just sign a contract that says that'll be negotiated later on. I wouldn't put that says he will consider anything. Just have it with no mention of what your client will consider. They can then, as a buyer, submit a request for repairs, and then your seller can look at it and determine whether they want to counter it, do the repairs, or credit and lieu. But I don't really like contracts, RPAs, or counters that contain what we in law call precatory comments, meaning maybe I'll pay for that if I like it, or maybe we'll negotiate the cost of that, and maybe I'll pay it and I'll consider it. That serves no purpose other than confuse all the parties. So I would leave it all out and just write it clean and just tell the selling agent, when you get your repairs done and you got your lender's stuff together, put it in writing as a request for repair, and then we'll look at it and then present it to your client, and then your client can make a determination. Okay? Yes, ma'am.
Oh, I have questions about commissions, compensations, the proper verbiage, and when we can tell them, if, as a listing agent, how much I'm gonna pay for compensation.
Okay, well, I mean, I have a newsletter that's been circulated that contains like 3 samples of language to use on your RPA, on your RLA, for example. So when you sign a client up as a listing agent, there's language that I recommend that you use, and it's in my book too, by the way. But it's been circulated to this office, but I don't know if everybody received it. It sounds like maybe you haven't received it.
Okay.
But it was done months ago, and then I did it again, and now you're gonna have it when you buy the book too. So then you'll have it permanently and indelibly marked on your desk. But there's language that I have that addresses things like how do you document dual agency, how do you document when it's only one party, how do you document when it's a for sale by owner, and I have certain language that you now can put on an addendum to the RLA, which is actually a modification of terms. MT-LA is the term, is the form that you use along with the RLA in order to document dual agencies and things like that.
But can we actually put the compensation on our flyers? I'm getting conflicting.
You can do any of that as long as your seller says it's okay. So when we write up your RLA, just say they authorize you to offer, 3% to the selling office. Then you can do it. The only place you can't do it is the MLS.
So
It's the
we're
only
not
place in
gonna
the world.
get fined or anything
No,
from
No.
DRE or?
The only place you cannot put it is MLS. You cannot go in the MLS. That's a private country club rule they came up with
Can
after
we use the
NA.
term commission or do we have to use compensation?
You can call it commission, you can call it compensation, you can call it dollars, you can call it income, you can call it whatever you want. You can put it on the side of your car, say 3%. Every house I have listed is 3%. Don't matter. There's only one place you cannot put it, MLS. If you put it in the MLS, you will be fined $2,500. And I've seen that happen already, by the way. I've seen that happen twice because they kind of conveniently put it in there in a way that they didn't like, and the seller, the listing agent received a violation.
I'm just getting conflicting stories from like a board from IVAR and different boards that come and talk to real estate professionals at some meeting I come to, and it's totally confusing because they're saying you can't even say commission, you're gonna get fined, and they're being real strict.
I haven't seen any law,
That's
any
right.
rule, any CRMLS rule or regulation that says you can't use can't speak free language and use the term commission
Thank
in connection with the sale. So what I would do is I would continue to use it everywhere except the MLS. By the way, now just keep in mind, you can't have anything in your site that would skew to an MLS listing and offer commission. That would be a violation. They don't want commissions in MLS and the MLS site in the same like website. So you couldn't have those two linked together. So that's true. But on your flyers, on your handouts, on the side of your car, you put all over your t-shirt, whatever you'd like. You can have commission that's being offered. As long as it's not where? MLS. That's it. That's the only regulation that I've read. You can read it in Rule 9.1. Yes,
Another off topic, so,
we're all off topic right now.
right. Arbitration and mediation clause.
Yes, my favorite.
Yeah.
I made a lot of money off those two.
Well, this is, you know who you're talking to? Sonia Coffey.
Yeah.
Okay, so you know the deal I'm in right now. I need to know going forward, because my client signed that clause and there are other damages, but because he signed
Right.
that clause.
Here's gonna be my comment on that, because that's a very specific active
But not even
dispute.
specific, because it came
Hold
up
on,
before,
hold on.
because it
Because,
wasn't.
no, wait.
Okay,
Because it's a very specific active case, I wanna talk to you one-on-one.
okay,
Because there's client confidences, now that the
Yeah.
client has an actual claim
Yeah.
arising from the office, I wanna talk to you one by one.
okay.
That's not public
But
consumption,
put that aside,
okay?
I've had clients not want to sign that. I
Okay.
turn my forms in,
Yep.
they reject it, say it needs to be signed.
Okay,
Okay, but what if but that's not okay, because if.
well,
my
if they don't wanna
client-
sign it, they don't have to sign arbitration, they don't have to sign liquidated damage if they don't want to. You then need to have a discussion with your client, say, is this a material term to your transaction or not? So, I mean, do we desire liquidated
But our
damages? We
office
do.
requires that to be signed, correct?
No.
A lot of them,
That's an
even
option.
if
Yeah,
it is
it
signed,
does.
you know, like, actually, Rod can kind of explain, even when that is signed, sometimes it'll go immediately to litigation.
Right, but they're not.
The recommendation is the liquidated damage and arbitration be signed. But if the client you have doesn't want to sign it, if they say, I'm not signing arbitration, and all of us that have represented lawyers,
Because
there's
it
no
lim-
lawyer that's gonna do a deal with you and sign arbitration. There is,
No, But because it limits them to only the EMD.
oh, well, no, arbitration doesn't, liquidated damage clause limits it to EMD.
Okay, I'll do that.
Yeah, okay, all right.
Going back to Q5 and Q6.
Yes.
If they're already in the contract, can they be removed later and then addendum if they agree to sign?
Not, with an addendum, what kind of addendum? You mean if you get an offer, if you receive an offer today and it says 3Q5 and 3Q6, seller, then you would do a counter offer and say, no.
And if you didn't, and you later on do it.
You mean after the deal's signed?
after-
It's done.
Can't do it after.
No, it's easy. No, it's easy. The only time you can do it then is if you do a request for repair and then eliminate it somehow through the negotiations. But it's too late. I mean, you can't unring the bell.
Right.
I mean, once you've signed the contract, the bell rung and you can't unring it. You can't put Humpty Dumpty back in the wall. Humpty Dumpty's down. Okay? Simple as that. Okay? This is your time now, Q&A. Whatever you guys like. Yes, ma'am.
About the inspection for the two-story or something.
You know, you're talking the balcony?
Yeah.
Yeah, you know, there's not too much to talk about that. I don't know enough about it. I haven't seen it in play. I know we're getting some revised forms in December. And once we get the revised forms, I'll come back in January, we'll talk more about it. So I'm not quite sure where that's gonna fall, but we're gonna have some forms about it, some revised forms.
Because they said like a two-story home, you have an inspection.
Yeah.
in certain time
It's
of-
balconies, it's not 2 stories, balconies. It only applies to balconies. Yeah, and there's very specific requirements of what properties it applies to, okay? So we'll be more equipped to talk about that later, once the forms settle down. This is a relatively new disclosure, it's been less than 9 months, and it's I've heard it described awfully by multiple people in conflicting ways, and so I'm not really sure what they want from us on it. As soon as I can figure out what they want, I'll come back and I'll tell you.
Okay.
There you
Last
go.
question for me.
Him and then you.
Okay, one last thing,
Yes.
how many notice to buyer to perform you need to send to be able to cancel?
Oh, I love,
One
oh,
is enough or two?
hold on, this is my favorite topic in the world. I love notices to buyer to perform, I love notices to seller to perform, and I love demands to close escrow. Why do I love that? Because once contingencies are removed, nobody can cancel without one of those 3 forms having been served. Flat out. So if you have a buyer or a seller that's canceling after contingencies were removed, you gotta have one of those in your file. So you have a notice to buyer to perform and a notice to seller to perform. They both have a 2-day window of expiration. Then on its own, you have a demand to close escrow, and what's the window of expiration on that? 3 days. So you serve a notice and the timing on this is what's critical. And everybody jacks it up. You're not the only guys. Everybody jacks it up. So here's what we have. So on Wednesday morning at 9 o'clock, you serve a demand to close escrow. Anybody want to take a wild gander when it expires and your buyer can cancel? Or your seller in that case can cancel? We got a Friday at midnight. What else do we have?
So it's 3 days.
What do you have?
It's a 3 days.
My question is, when I should probably,
Oh, we're still on this other
Yeah.
topic. Sorry, hold on. What's yours?
It's a 3 day, no? It's a 3
Yeah,
day.
3 days.
3 days.
So
3
it's
days.
Wednesday.
Amanda, close that.
So you come Wednesday, Thursday, and Friday. And because it's gonna be the weekend, how it's gonna?
Yeah, here's the deal. So here's how you calculate it. And I can tell there's confusion. There always is. Every office I talked about this topic. So you have a demand to close escrow. It has a 3-day expiration, and you serve it on Wednesday morning at 9. Always remember, the day you serve a demand to close escrow, a notice to seller to perform, or a notice to buyer to perform is always day 0. So it doesn't matter if you serve it at 9 in the morning or 9 at night. So Wednesday is what day?
It's 0 day.
0. Thursday. Friday. Saturday. So what time would it technically expire? 11:59. But the RPA says if the expiration happens on a Saturday, Sunday, or a legal holiday, it kicks over to the next business day at 11:59. So it expires 11:59 on Monday if served on Wednesday, which means your client as a seller can cancel when? Tuesday. So always remember, whether it's a notice to perform or demand to close escrow, the day you serve is 0. And if the expiration falls on a Saturday, Sunday, or holiday, just wait till the next business day, 11:59 p.m., then cancel the next day after that. Simple as that. So if you served a notice to buyer to perform today, Monday, day 0. Tuesday, Wednesday, 11:59 it expires, your client can cancel on Thursday. Simple as that.
But we have to have the contingencies removed. We already have, anyway, we need to have the contingencies removed.
If you represent a buyer and you get a notice to buyer to perform to remove contingencies, the general answer is you have 2 days expiring at 11:59 on the second day to remove contingencies. If your buyer doesn't perform, the seller has a contract right to cancel and your buyer gets his deposit back. That's typically the answer. Okay?
I don't know where people get someplace about that.
Well, if in doubt, add another day. Because if your client cancels a day early, what does that mean? Your client is now in breach of contract. Did you have one last question?
I did. Do you accept Zelle for your book?
Zelle, just cash, yeah.
Oh, really? Okay.
Yeah, just yeah, so there'll be enough floating around for a long time. This is the very first, we ordered just 50 initial copies, just to make sure they're 100%.
For 100?
We will by the time everybody else buys. Yeah. You know what normally happens? My wife retired this year, so she's at the office part-time working, and she has all the cash, the small cash. And she went, I don't know, she took off, so now I don't have small cash. That's what happened. I'm still getting used to having a retired wife. It's a little bit of a problem. Any other questions before we go to the book? Yes?
So, financial property, is like a company employee, and they sign the PRBC, but after the boss buy the house, how I can figure for this?
Okay, well, I mean, it sounds to me like you're gonna have there's a form, there's a CAR form when somebody's signing in a representative capacity. So if you look on CAR forms, if you're telling me is there's a company buyer, and if it's a company buyer and an officer is signing, then you have a representative, there's a representative signature form you need to have in the file. That then whereby that signatory says, I have the authorization to sign on behalf of XYZ Corporation. Okay, that's what it is. So it's just an additional form, if that's what you're asking. Okay, yes.
And you said, give me a call. What's your number? Because you're saying, call me, if you have questions, call me.
Email, rod@fehlmanlaw.com. But remember, if you're emailing me on a file, like a dispute on an active file that's pending, make sure you copy the broker as well, so that they're in the loop on what we're talking about. That's one thing I noticed a lot of the agents and all the offices across the board fail to do, is they don't necessarily keep the broker involved. I had one case 3 years ago that we went to the doors of mediation and the broker had no idea we were doing this. Because the agent was communicating with me, and then when I talked to the broker, I said, we've got mediation in the morning, And the broker said, what are you talking about? So just to avoid that, when you email to me, make sure somebody at the executive level gets an email as well, gets a CC, so they know what we're talking about.
Rod at
FehlmanLaw.com. Fehlman Law. When you buy the book, you'll have the exact spelling of the book. All right. Any questions? Going once? Going twice? Thanks for having me here. Hopefully everybody's a little smarter than when I stepped in the door. Please don't forget to buy a book. Yeah.